Interest in property. Since the United States money system is based on interest in property rather than substance, the commercial goal is to get a security interest in something that has value, not to take possession of a thing. Ownership carries liability. Interest in property does not. It is more efficient commercially to have a security interest in property than to own it. A security interest is not given unless there is an obligation that necessitates such an action. That means there is a debt involved when there is a security interest. When one applies for credit, he simultaneously gives a security interest in a things that has value. The thing can be a title to land or a car, uh, title to deposit account at a bank, a promise of future performance, or a commitment on future labor. The security for the credit can be implied and constitutes consideration. This implies the existence of a contract, even though it may be a simple contract and you may not have intended to enter a contract. Default on implied contracts can result in consequences anywhere from seizure of pledged property, titles, or even a body to negative information on a credit report. The blank endorsement of of a transferee who does not do anything with an instrument that was issued or transferred to him for value is assumed. At some point, he is a holder and is liable, but the liability is not enforceable until there is an endorsement, which can be on another piece of paper that is attached by a connective note, or can just be presumed according to the commercial law. Someone other than the transferee can even sign it on behalf of the transferee. This is not done unless the transferee is arguing or continually objecting to being billed. Technically, the transferee is in default, so his negligence or disobedience can be cured by someone else, but there is usually an additional price to pay at that point. An actual endorsement that fits the commercial requirements might even be on a paper used in a penal action proceeding called Terms and Conditions of Release. It is a special bond used in penal action courts when the defendant still refuses to take responsibility to close the account. UCC 3-203, Transfer of Instrument Rights Acquired by Transferor. C. Unless otherwise agreed, if an instrument is transferred for value and the transferee does not become a holder because of a lack of an endorsement by the transferor, the transferee has a specifically enforceable right to the unqualified endorsement of the transferor, but negotiation of the instrument does not occur until the endorsement is made. This is a confusing section of the commercial code. The position of the transferor and the transferee switch when the original transferee fails to respond. The mere act of retaining an instrument implies its general acceptance and is reissuance with a blank endorsement. This turns the tables. It turns the original transferee into a new issuer transferor and the maker or drawer on an instrument. The original issue becomes the transferee. For example, according to UCC 3-203, the U.S. citizen who received the instrument and was originally the transferee with an automatic security interest in the instrument that was issued and transferred for value becomes the new issuer and the transferor if he just receives it and retains it. The United States agent that originally issued it for value and had the liability to pay it becomes the new transferee with a security interest in the instrument. The new transferee has a specifically enforceable right to the unqualified endorsement of the transferor. All the United States has to do is get the U.S. citizen to sign anything that is related to that instrument. It could be the green card on a certified mail envelope, or a payment agreement with the IRS, or a terms and conditions of release bond in an executive court proceeding. Settlement. Handling negotiable instruments is just the first step of settling commercial accounts in the United States. Article 3 of the Commercial Code is the guidebook for dealing with negotiable instruments of all kinds. Registration and bonding through the Secretary of Treasury as your fiduciary and securities intermediary, and setting off commercial charges is needed to actually settle the accounts. Directions for registering a security interest is found in Article 9, and the duties and rights of parties to securities are covered in Article 8. Knowing what acceptance for value means is just the beginning. Acceptance for value recap. Acceptance for value is purely a commercial remedy. It is not the only remedy. Acceptance for value is based on contract law and international law. Even simple contracts must have consideration from both sides to be valid. Bankruptcy law and insolvency law overshadow all commercial debts in the United States. The president is the only officer of the United States who has a constitutionally required oath. People are beneficiaries of the trust created by the Constitution. The president is the executive trustee of that trust. Acceptance for value is different than acceptance. Value can be 1. A commitment to extend credit, 2. As security for satisfaction of a pre-existing claim, 3. Acceptance of deliverer on a pre-existing contract, and 4. Any consideration sufficient to support a simple contract. Mere acceptance waives defects. Accepting an instrument for value gives the acceptor options. The issuer of an instrument has the liability on the instrument. An instrument issued or transferred for value is 1. For a promise of performance to the extent the promise has been performed, 2. To acquire a security interest or other lien in the instrument other than a lien obtained by judicial proceedings, 3. As payment of or as security for an antecedent claim against any person, whether or not the claim is due, 4. In exchange for a negotiable instrument, or 5. In exchange for the incurring of an irrevocable obligation to a third party by the person taking the instrument. One of an acceptor's options is to accept for value and return for value to the issuer's bank or banker. Article 8 of the Commercial Code directs the handling of securities in the United States. A securities intermediary has obligations to entitlement holders. Consideration means any consideration sufficient to support a simple contract. An issuer of an instrument for value has no defense to the obligation to pay the instrument. The issuer has a defense if performance of the promise is due and the promise has not been performed. An instrument is issued of transfer. An instrument issued or transferred for value is also issued for consideration. A person gives value to receive rights. He can acquire rights, A, in return for a binding commitment to extend credit or for the extensions of immediately credit, B, as security for or in total or partial satisfaction of a pre-existing claim, or C, by accepting delivery pursuant to a pre-existing contract for purchase, or D, generally in return for any consideration sufficient to support a simple contract. Acceptance for value is the same as taken for value. Instruments issued for value have no value in them until they are endorsed. A blank endorsement makes the endorser liable on the endorsement. A proper qualified endorsement can make an endorser a holder in due course. An endorsement is not required to take on the liability of the instrument. An endorser has the option of limiting or precluding recourse against himself. An endorser decides if an instrument is a promise or an order. An endorser decides if an instrument is negotiable or non-negotiable. An endorser decides if an instrument is a payment or a security interest in property, establishes a claim that may be enforceable by a holder in due course. Interest in property does not carry liabilities or ownership of property. Thank you for joining me, and this completes our 6th series of acceptance for value and what it means.